Good afternoon. This is Russell Berger of Offit Kurman. We're going to sit tight for just a minute to give a few more folks a chance to log on to the webinar, and we'll get started in just a minute. All right, let's begin. Good afternoon again, and welcome to Wage and Hour Law Part 1, How to Correctly Classify Workers. Today we will cover how to correctly classify workers, both as employees and independent contractors, as well as with respect to the exempt, non-exempt distinction. Misclassification is one of the most common reasons employers face Fair Labor Standards Act lawsuits for overtime pay, and as a result, proper classification is the first step in overtime compliance. Before we get started with today's webinar, feel free to submit questions as we go, and I'll try my best to answer as many as possible. I'll likely take a number at the end of the webinar. Again, my name is Russell Berger. As a trusted legal advisor, I help business owners take on the challenges that come with running a business. As the chair of the Labor and Employment Group here at Offit Kurman, I spend a large portion of my time addressing wage and hour issues in both the litigation and compliance contexts. Now, both federal and state laws require certain employees classified as non-exempt to be paid minimum wage and overtime premiums. In my experience, there are three general categories of wage and hour issues, or three areas where employers tend to get off the rails a little bit. The first is misclassification, which we will discuss in more detail today, but that typically addresses whether or not an employee should receive at least the minimum wage and overtime premiums or not. The second category is timekeeping, which covers where there are disputes over the hours worked. And the third area of frequent issues with respect to overtime is with respect to miscalculation of the rate at which overtime hours should be paid. So ultimately, overtime compliance can be summarized in three simple questions. One, is the worker eligible for overtime? Two, if yes, how much did that person work? And three, what is the person owed for that work? And today we're going to be talking about the first of those questions, is the worker eligible for overtime? And I think it's really the most critical, because if you classify someone as an independent contractor or an exempt employee, then as an employer, you're unlikely to be able to get the other questions right if you're wrong on the first one. So for example, if you classify someone as an independent contractor, you don't track their hours, which means you don't know how much they worked, which means you can't possibly pay them the right amount if they're ultimately proven to be a non-exempt employee. Now, before getting into too much detail on the classification issue, I wanted to touch on timekeeping and miscalculation just in general. Not only is timekeeping of non-exempt employees required, without good time records, it is impossible to prove wage and hour compliance. It is impossible to pay the correct amount of overtime pay to a worker if you do not know the amount of hours that person actually worked. So, as a foundational principle, non-exempt employees should not be permitted to work without recording time. The law can be pretty specific about what it means to work, whether a time off is a meal break or it's a rest break that should be counted as compensable work time. Those are some of the details that we're going to get into next week on part 2 of this webinar series. But just as a general principle for today, and for anyone who doesn't register for the subsequent webinar, it's very, very important that any non-exempt employee tracks their time. It's a requirement of the law, and it's just necessary in order to do what you need to do to be compliant with the more onerous portions of the law. Like timekeeping, it's also critical for employers to understand what premium they have to pay when a non-exempt employee works overtime. If an employee is paid by the hour, the math is pretty simple. For example, an employee that makes $10 an hour gets paid $15 an hour for overtime, which is hours worked over 40 in a week, because the law says that overtime is paid at 1.5 times the regular rate, or time and a half. However, the regular rate is more than just the hourly rate. It includes other types of compensation as well, such as commissions, performance bonuses, volume bonuses, and more. Therefore, it's critical that the different forms of compensation are tracked and included in the overtime calculation. What we often see is employers will pay someone by the hour, but neglect to incorporate commission pay or other bonuses that are required to be incorporated into the regular rate into the overtime premium, therefore causing a deficiency in the amount of overtime that's actually paid when contrasted with what the law actually requires. Again, this is something that the third part of this webinar series will cover in more detail. So, as I mentioned at the beginning, misclassification is the most common cause of overtime litigation. And, being an active practitioner, I often hear from clients things like, I pay that guy a salary, so I'm good, right? And of course the answer to that is no, because while paying an employee a salary is certainly easier for a lot of employees in some cases, because you don't have to track time or calculate overtime premiums or pay overtime premiums, it's not that simple, and it's not entirely up to the employer to make this choice. So while salary is often a component of many of the exemptions that would allow an employer to avoid having to pay overtime, in order for an employee to be classified as an exempt, not eligible to receive overtime pay, an employee must satisfy one of the statutory exemptions. And there are a number of exemptions, and we'll discuss the most common exemptions today. Similarly, one of the other issues that I frequently run into is, I hear from clients where they say, oh, that person's a 1099 employee, so I don't need to worry about overtime for him. That sentiment is also incorrect. There's no such thing as a 1099 employee. Someone is either an employee, who may be exempt or non-exempt, or an independent contractor. And like the exemption statutes, this is a legal question with a legal test. So as we go through, and we're about to dive into some of the exemptions here, I wanted to give you all a little bit of context about how I conceptualize the exemption analysis. So I generally start off, if someone asks me, hey, is this position exempt or not, I start from the premise that the employee is non-exempt, meaning that they're entitled to minimum wage for all hours worked and for time and a half of the regular rate for all hours worked over 40. And the reason I do that is because the penalties for being wrong in that question are significant. And if someone files a lawsuit, if an employee files a lawsuit under the FLSA, and they establish that they were entitled to overtime pay that they did not receive, there's a provision in the FLSA that it's not quite automatic, but it's pretty close to automatic. But effectively, an employee is going to get double the wage. So, for example, if someone proves they were owed $5,000 worth of overtime pay, the law is likely to award that employee a judgment in the amount of $10,000. In addition, that employee is also going to be eligible to receive their attorney's fees for pursuing their claim against the employer. So there's another sum that's going to get added on to that wage portion. And while at the same time, the employer is probably going to have to pay an attorney to defend itself against these claims or even to negotiate a resolution. In addition, one of the Maryland state laws that applies here has provisions that could multiply the wage by 3 as opposed to 2. And that's a little bit harder to trigger than the double penalty under the federal law, but damages could be triple, so that $5,000 could become $15,000 in theory, along with attorney's fees. Additionally, the FLSA contains a provision that makes it easier for employees to join together and pursue these overtime claims as a class. So, for example, if you have 10 people working in the same job and there's a misclassification issue and one of them realizes it and files a lawsuit, you could be dealing with a lawsuit brought by anywhere from 1 to 10 people now. And so, that $10,000 or $15,000 exposure could get multiplied by 3, 5, 10, and grow a lot larger. So I tend to be very conservative in the way I look at this. And if it's not convincing evidence to me that the position is exempt, then my counsel generally is, look, you're taking a big risk if you classify this person as exempt. But that being said, there are ways to make out the exemptions, and there are some bright lines. So the first exemption that we're going to look at today is the administrative exemption. And as is the case for many of the exemptions, the administrative exemption has 2 main components. One is the primary duty test, and the second is the salary basis test. And I'll start with the salary basis test. Presently, the salary basis test is incorporated into a number of exemptions, and it requires that in order for the exemption to be made out, the individual has to be paid at least $455 per week in salary, regardless of the number of hours worked. So if they work 20 hours in a week, if they work 60 hours in a week, they work 40 hours in the week, they have to be paid at least $455 per week. No exceptions for days missed, or I should say very limited exceptions for days missed. And as many of you might recall, this was a big issue in the fall of 2016 because the Department of Labor had announced that the salary basis was going to increase. It was still going to function in the same way, but the number was going to go from $455 per week to $913 per week. And many of you on this call probably took steps to get into compliance with that change in the salary basis level, and about less than a week before that was to go into effect, a court in Texas entered an injunction that precluded it from going into effect, and subsequently, under a new administration, the Department of Labor hasn't really pushed this and isn't all that interested in raising the $455 per week threshold. So as a practical matter, when analyzing the salary basis component of any exemption, $455 per week is very low. And anybody who is going to make out the primary duty portion of the analysis is got to be making at least $455 per week. It works out to something like $23,000 per year. Nobody who's making less than that is going to satisfy the job duties test. At least I've never seen it. It's theoretically possible, but the issue is that with the salary basis that low, it's not really that big of a factor in the analysis. However, you do have to make sure that a salary is being paid and that there aren't, it's being done in a proper manner so as not to cause it to not be considered a salary and cause problems with the analysis. So that being said, for a lot of these exemptions where the salary basis is incorporated, the real, the rubber meets the road when it comes to the primary duties test. And so with respect to the administrative exemption, a common misconception is that this is the work of an admin or an administrative assistant. That's not the case. The administrative exemption covers the type of work that could be done at any company in any industry. So, for example, many businesses have an accounting department, a marketing department, or some sort of human resources function. These are the types of positions covered by the administrative exemption because they directly relate to the management of or general business operations of the employer. So really, the idea here, at least in terms of general category, is you want to think back office administrative function and not production. So if you have whatever your company does, the people that produce that product or that service are not likely to fall within the administrative exemption. However, the accounts payable person, the accounting person, the HR person, quality control, those sorts of functions are generally what's covered by the administrative exemption. It's really the administrative functions of a business that are covered. But even then, it's not everybody that works in those departments or does that type of work. Instead, it's people whose primary duty covers that type of work, but who also have a primary duty that includes the exercise of discretion and independent judgment with respect to matters of significance. So that's not necessarily like C-level people only, but it's more than simply following instructions or carrying out tasks. So there's cases that talk about quality control people or auditors that are given checklists and review files using those checklists, and who are held to be non-exempt because while they're performing an administrative function of the business, they're not engaged in any level of judgment or discretion. So really what this exemption requires is some level of independent thought. And so if you're actually making decisions, if the auditor doesn't have a checklist but instead is conducting investigations and researching and analyzing, you're more likely to make out the administrative exemption than if you're just kind of following somebody else's instructions and it's more of a paint by numbers job. I should mention that there's a grouping of 3 exemptions, the administrative exemption being the first, that are commonly referred to as the white-collar exemptions. And here, the professional exemption is the second white-collar exemption. And they're called the white-collar exemptions because, generally speaking, all of these exemptions apply to non-manual work. So like the administrative exemption, the professional exemption is also subject to the salary basis test, although for certain part-time situations or even full-time situations, there's an hourly fee option that could be substituted for the salary basis. That fee requirement is going to be greater than the salary, than the $4.55 per week, so it's not something that you see very often. So again, turning more to the primary duties component of the professional exemption, I'm subject to the professional exemption because I'm an attorney. And generally a good rule of thumb with respect to who's covered by the professional exemption is licensing. So as a lawyer, I have to pass the bar exam in order to practice law. So there's a kind of an independent objective threshold that I have to clear in order to work as an attorney. The same thing is true for CPAs and for physicians and even for some nurses. But as you can imagine, with in the nursing profession or even with accountants, there's different levels of some people are licensed, some people are not. So, for example, with respect to the world of accounting, certified public accountants have to go through testing. They're generally considered to be professionally exempt. However, a lot of accounting firms will hire staff accountants right out of college who haven't gone through any level of training or licensing, and that those people very well may not be subject to the exemption. So if you're in an area like that, you're going to have to do a little more digging. You're going to want to monitor it more closely. But aside from that, the professional exemption should be pretty straightforward because it's not that gray of an area relative to some of the other exemptions. I should also mention that the professional exemption can apply to creative professionals as well. So, for example, certain types of chefs in restaurants have been held to be subject to the creative professional exemption, and that's not that common. But obviously, there's some high-end restaurants where the chefs are creating and have been trained, and although not licensed, are meet this definition because they're engaged in some sort of inventive, imaginative, creative endeavor. So I'm sure you can imagine which restaurants where that might be likely, and other restaurants where that certainly isn't the case. But again, that's something that's a little more of a narrower exemption. The third of the white-collar exemptions is the executive exemptions. The executive exemption. Like the other white-collar exemptions, a salary basis test applies here. In terms of substance, this is the exemption that applies to supervisors. So, as you can see from the bullet points here, someone will qualify for the executive exemption if they're customarily and regularly directing the work of at least two or more other full-time employees or their equivalent, and they either have authority to hire or fire, or they have a meaningful voice in that discussion. And it's hiring, firing, advancement, promotion, discipline, things like that. So lots of times this goes off the rails because the manager in question is not actually supervising two or more full-time employees, or they're not actually they don't actually have sufficient authority. So with respect to the question of the number of employees, it needs to be two or more full-time employees or their equivalents. And that doesn't. So if you're supervising one person or a department of one, for example, you don't qualify for the executive exemption. Maybe there's a way to qualify for the administrative exemption, or maybe there's some other exemption out there, but you're not going to qualify unless you're actually supervising two or more full-time employees or equivalents. Then the second component of this is you have to have some actual measure of authority. So oftentimes this comes up in the context of somebody who's a team lead. So there's a sales team, and sales work would not qualify for any of the other white-collar exemptions, and as we'll see in a little bit, may or may not qualify for an outside sales exemption. But let's say this is an internal team, working on a sales floor, and it's a group of 5 salespeople, and there's a team lead for that group. And the team lead's job is to coordinate the calls and divvy up the leads and to help people on the team with questions. Now, that person, while they have some level of managerial responsibility or they play some kind of supervisory role, isn't actually supervising the members of the team in the way that's required to satisfy the executive exemption. So that team lead, if that team lead were paid a salary as opposed to being paid by the hour, there would potentially be an overtime problem there because the person would be misclassified. Another area where we see this often is with respect to assistant managers. I've seen this a lot in the retail context, but I think it's broader than just retail. And the issue is that, this has happened, I think, in banks and big box stores. The assistant managers are taking on a lot of operational responsibility, but they're not managing the employees, and they don't have this hire fire authority, or they're not really managing the employees so much as they're managing the operations. And that's an issue where employers have to be very careful to make sure that if they're classifying someone as exempt, they're actually meeting this definition of what it means to be an executive under the FLSA. So as I just mentioned, there's another exemption called the outside sales exemption. This exemption does not require the salary basis test to be met. And what the outside sales exemption does is it creates no salary requirement, no hourly, no overtime requirement for employees that are making sales or obtaining orders for sales away from the employer's place of business. So I like to think of this as kind of the door-to-door salesman exemption, and the obvious inference from this exemption is that these workers are going to be working on commission. But if you think of it as someone who's outside the office generating sales, and maybe comes in the office every once in a while to fill out some paperwork or take care of things of that nature, but is primarily on the road making sales. There's a recent Supreme Court case a couple years ago involving pharmaceutical reps for drug companies, and in that case, the Supreme Court held that the definition of making sales or obtaining orders is very broad, and because if you think about it, a pharmaceutical rep doesn't actually sell anything to the doctors. The pharmaceutical rep pitches a drug or a product to the doctor, who then prescribes that drug to a patient, and the patient goes to the pharmacy and buys it there. But the Supreme Court held that was sufficient to constitute selling. So it's a relatively broad definition of sales, but it still has to be away from the office. And different states have the federal requirement does not have a threshold for what it means to be customarily and regularly engaged away from the employer's place of business, but some states do. I don't believe Maryland does, but certain states have 50% requirements, 75% requirements. Some are lower, some are more. So if you have outside sales employees working in multiple states or working in any state, you should look at the state requirement as well. Another note to touch on here with respect to the outside sales exemption is what it means to be when it says the employer's place or places of business. So obviously the office is one of the employer's place of businesses or places of business, but the employee's home office could constitute an employer's place of business as well. So oftentimes in constructing contracts with outside sales employees, I'll include things that say like you're not to maintain a home office, or you're to not you're not to work from home, or if you are, it's very limited, because you want to control that, because you don't want to accidentally have someone who's sitting at home a lot more than you think and then turns around and sues you saying, hey, I work from my home office 50-60% of the time, I really am non-exempt, you owe me overtime and minimum wage. So that's something to be careful with on outside sales employees as well. And that's especially the case across a large sales force, because you're going to have different people that are going to work differently, and that's okay. But I think as an employer, you want to make sure that there's a comfortable threshold or a comfortable floor, so that you're confident that everyone who you're classifying as outside sales is in fact outside sales, and if they're not working to that standard, then you convert them to inside sales. And in that vein, I think in the last week, the Supreme Court held that arbitration agreements for employees with collective action waivers, meaning that in order for an employee to sue an employer, they have to do so in arbitration by themselves, are valid. And while I'm not a huge fan of arbitration provisions in employment agreements as a general rule, if you have a large sales force and you want to avoid the risk of a class claim being brought, the use of a collective action waiver coupled with an arbitration provision, might be an effective strategy for you. All right, turning to the next exemption, this is the computer professional exemption. Again, this is subject to the salary basis test or a fee basis requirement. And essentially, this is a very technical exemption. And frankly, I don't think the legal system is entirely caught up here. So this is a four option primary duty test, and ultimately, if you get into a dispute over whether someone's subject to this exemption or not, it's going to be decided by a judge. And I would say, at the risk of stereotyping judges, they're probably not the most tech savvy group in the world, and they don't necessarily understand the nuance of the different jobs that exist in the IT world. So the way I like to think about it is as a continuum. And on one end, you've got employees that work on a help desk. So you have something wrong with your computer, you send a ticket into the help desk, and they call you up, they maybe log onto your computer, and they help resolve your problem, with troubleshooting. That's what they do. That person is, I think, pretty clearly non-exempt, and is going to have to be paid by the hour, track their time, paid overtime premiums. On the other end of the spectrum, you have what I would call a system architect. So someone who designs the system, builds the servers, designs how all these different servers are going to and softwares are going to interact with each other, ties all that stuff together, designs the whole technology setup for the business. That person, I think, is pretty clearly exempt. And the problem that then exists is there's a lot of in between those two ends of this continuum, and I don't think the case law has caught up to the practice, and because of that, I think there's a lot of uncertainty, and it creates challenges for employers as to what to do with their employees that would fall somewhere in this continuum. My general advice is, look, if you're dealing with troubleshooting or you're getting closer to troubleshooting, then probably non-exempt. If you're getting to the point where you're designing things and you're engineering a computer system, then I think you are more likely to be exempt. And so you're going to have to look at the specific job and figure out where it falls on that continuum, and still know that if you classify someone as exempt, there's some degree of risk just because it's not totally fleshed out. And again, I'm not sure that the judges of the Department of Labor are the most qualified or most capable of discerning the nuance in this type of work. All right, so the last exemption that we're going to cover today is the highly compensated employee exemption. And I kind of refer to this as the diet white-collar exemption. And so what it says is that if you make at least $100,000 per year, which includes, it can be a combination of salary and bonus or salary and commission, but what at a minimum includes the $455 per week in salary, then you can still be considered exempt if, even though it's not necessarily your primary duty, if you're customarily and regularly performing at least one of the duties of a white-collar exempt employee. So, essentially what Congress did in passing this, and the Department of Labor has continued, is determined that if you make $100,000 a year, we're not really all that concerned about protecting you from being from abusive practices by your employer with respect to your compensation, as long as you're close on one of the primary duties test, then we're gonna consider you exempt. Because the idea of the law is not to ensure that people that make $100,000 or more per year get overtime premiums. That being said, there are inside salespeople that make well more than $100,000 per year that would still have to be non-exempt. So it's not right to think of this as, well, you make $100,000, you're good. It's more accurate to think of this as, you make $100,000, so I can be a little looser on the application of the job duties test, but I still want to get it pretty close and feel pretty comfortable about it under any of the white-collar exemptions. So now that we've covered the exemptions, another area where the the misclassification issue rears its head is with respect to the distinction between whether someone is an independent contractor or an employee. So along those lines, I've heard all these things before. You sign an independent contractor agreement. I don't have to worry because I pay my workers by 1099. My competitors do it this way, which frankly I hear a lot of that. And it's like the old adage you say to your kids, just because Jimmy jumped off a bridge, would you do that too? And of course not, but we still hear that a lot. I'd rather my employees be independent contractors because I don't want to pay them. I don't want to pay them overtime. I don't want to pay them benefits. I want to avoid all of that. And then, as we'll get to in a second, there's a number of tests that apply to this independent contractor employee distinction, and oftentimes employers don't want to deal with all of them. So the reason there are different tests, though, are because there are different laws. So the independent contractor employee distinction not only affects the wage payment laws, so the FLSA and the Maryland Wage and Hour Law and the Maryland Wage Payment and Collection Law, but it also affects other things like unemployment. Someone's an independent contractor, you're not paying an unemployment premium. If someone is an independent contractor, you're not paying workers' comp insurance, health insurance, under the Affordable Care Act. And so, there's the tax laws as well. So there's a number of different reasons why this distinction is relevant, and each of those different laws has a slightly different test. Since we're covering overtime today, I'm going to talk about that test, which in the Fourth Circuit is called the economic realities test. But that being said, the economic realities test is probably the most strenuous of the tests. So if you can satisfy the economic realities test, you're likely to satisfy any other test that might be applied. For example, if the DLLR came to investigate for purposes of seeking back contributions to the unemployment fund. So with respect to the economic realities test, different courts at different places have different tests, but this is relatively common. And I should add that this test is a little more uncertain than maybe it used to be, as the Fourth Circuit, which is the circuit court that sits covers Maryland at the federal level. The Fourth Circuit has been reconsidering this, and has had some recent decisions that caused me to feel a little bit of uncertainty with respect to these 6 factors. But that being said, as you can see, this is a multi-factored, fact-specific test. And so it's really hard to say without knowing an exact fact pattern how this test plays out. This is also what's called in the law a totality of the circumstances test. And what that means is that no one factor necessarily controls the outcome, but instead a court is going to look at all the facts that pertain to each of these factors and then make a decision based on consideration of all of that, which from a lawyer perspective makes it somewhat hard to predict exactly how a judge is going to rule when you're in a gray area. And it's one thing, if I represent a client that gets sued and we're defending a lawsuit, we're just going to make the arguments because what choice do we have? We've already been sued. But from a compliance standpoint, or hopefully for everyone on this call, you're not being sued, but you want to make sure you're getting this right. It's a little bit harder to gauge. So again, like I said with the exemptions, I tend to think that unless you can come up with a strong argument as to why someone's an independent contractor, it's certainly less risky to treat them as an employee. Again, an independent contractor, so we all have examples of independent contractors that we probably all hire. The plumber, the electrician, somebody who comes to your house, and does work for you, but they come at their own schedule, they bring their own tools, they wear their own uniform, they have all their own equipment, they send you a bill or they give you an invoice that you have to pay. Those people are all independent contractors. And so while there are certainly relationships that are less independent than that can be classified as independent contractors, that's kind of what you're shooting for as you go through these factors. So, and a lot of this really comes down to the level of control that the business has over the worker. So, it's with respect, and that's with respect to not just the equipment or the schedule, but how the work is done, what methods are used. I'm certainly never going to tell the plumber how to do his job. He's just going to do it and give me a bill and I'm going to pay it. The closer you are to that, the more likely someone is to be classified as an independent contractor. Some of the other factors that get worked into this test are the worker's ability to sub out the work further. So, when I hire a plumber, they might send, the assistant or the new guy out to work on my problem. And it's just one guy who's doing the marketing and bringing in the business and then spreading it out to other workers, employees of his, but who are independent contractors of mine. So, similar principle applies. If it's something that you say, look, I just need this done. I don't care how you do it. Hire whoever you need or hire people, but with my permission. Those are the types of things that would be indicia of independent contractor status. And another factor that I think warrants touching on now is the last factor, which is, if I work at a law firm and we hire someone who's licensed as an attorney to do legal work, the legal work is likely to be an integral part of what my firm does. That's not always the case because there are certainly instances where you can hire contract attorneys to do document review, but you want to draw a distinction between what it is that your business does and what it is that you're contracting out. And again, it makes it, sometimes you see a situation where there are employees and independent contractors that are doing the same job, working side by side, and some are classified one way and some are classified another, that's a problem, and it means that the independent contractors are probably really employees. So if you have different classifications doing the same type of work, that's cause for concern, and that's definitely something you should look at a little bit more closely. All right, so as I alluded to at the beginning with respect to the exemption classification, some of the it's a similar consequence with respect to misclassifying someone as an independent contractor when they're actually an employee. You're going to have to pay any wages that are found to be owed. You could have that doubled or tripled. You could have attorney's fees added to the mix, and you could have class litigation in addition to having to pay a lawyer to dig your way out of this. I mean, even if you decide, hey, I didn't want to get out right away, that's not something that's necessarily all that easy to accomplish, and it's going to take a little bit of work to get there. Plus, you're still going to be paying the unpaid wages and some damages. So, with that being said, I'm going to take a look at some of the questions here, and if you have any other questions, feel free to to send them in. You should be able to do that through the controls on the webinar software. So one question we received is, if a job has 90% of payroll clerk duties and only a 10% of other functions that are more related to a salary employee, how can the employer properly assess if this person should be hourly or salary? With respect to that question, it's important to remember that when you're applying the exemption analysis, that it's looking at the primary duty. So, what's really the bulk of this person's job? And if the bulk of this person's job is doing non-exempt payroll clerk work, then that person needs to be classified as non-exempt. If they were a supervisor, for example, that helped out on payroll from time to time because they got the payroll crunch and they need to get through it, the answer might be different. But again, it's really focusing in on the primary duty. So if someone's spending 90% of their time doing what I'm assuming is non-exempt, not work because it's not rising to a level of, discretion and judgment as to matters of significance, then I think you need to treat it as treat that person as non-exempt. And there's no basis very rarely can you split someone and pay them at different rates for different times. So there's really, since this is a primary duty test, the fact that they're doing a little bit of exempt work doesn't convert them into an exempt employee. However, if they were doing some amount of exempt work and they were making $100,000 a year, then you might have an opportunity to classify them as exempt under the highly compensated exemption. All right, so the next question I have is, does hiring independent contractors through a staffing agency avoid the issue of misclassification? And the follow-up to that is, what if the independent contractor has their own business but is hired as an independent contractor to do the same type of work as employees? So, I can tell you, I've handled cases involving staffing agencies and, hired labor in the past. And there's something under the employment law called joint employer liability. So whether or not you hire someone from a staffing agency or not, there's still an ability for that individual to call you or to prove that you are his or her employer, because someone can have more than one employer. And in fact, individuals can held to be employers under these statutes. So if you hire someone through a staffing agency, they come to work for you and you manage them just like you manage the employees right next to them, there's a pretty decent chance that they're going to be held to be your employees. And there's ways around this, and there's ways to at least mitigate some of that risk, but there's certainly a real possibility that the worker is going to be held to be your employee, and once that happens, now you've got all the same obligations to them, just like you would any other employee. And in addition, it's also plausible when you hire through an independent contractor to bring their own labor force, that if you're exerting control over them, you're going to have some responsibility to make sure that the independent contractor that you hire is either paying their employees properly, or is indemnifying you. I guess I should say it's not a responsibility, but rather that's a good strategy, and a good way to mitigate your risk. And of note, the state of Maryland recently passed a law that said, with respect to the construction industry only, that all up and down the chain of subcontractors and general contractors, that everyone above the chain is going to be liable for that employee. So if you're the general contractor on a project and you hire an electrical sub who then hires a lighting sub, the employee of the lighting sub is going to be considered an employee of the electrical sub as well as the general contractor for purposes of the state law. So that's something to keep in mind as well. The next question that I have is, does a full-time teacher qualify as exempt? And the quick answer to that is yes. It's part of the creative professional exemption, and I didn't touch on it during the presentation, but the answer to that is yes, teachers generally qualify as exempt under that exemption. And if you have any specific questions on that, there's guidance from the Department of Labor that can help you out in that respect. All right, well that looks like it does it for the questions that we have today. I thank you all for joining this afternoon, and hopefully you found this informative and helpful. And if you'd like, we'll be doing parts 2 and parts 3 the next couple of Wednesdays, so feel free to register for those as well. Again, thanks for joining, and I hope to speak with you soon. And if you have any questions, or if there's anything I didn't answer today or you think of later, you've got my contact information. Feel free to reach out. Thank you, and have a good afternoon.